Hello and welcome to La Excellence Hyderabad and Bengaluru. This is the daily news analysis for 9th May 2020. So La Excellence has started its online live general studies prelims cum mains batch for 2021. It has started on 7th May 2020. All your queries, I request you all to direct to the given number here. Now let's move on to our discussion. As usual, the editorial articles will be discussed under the Daily Editorial Enrichment Program or DEEP, and the rest of the important articles in the newspaper will be discussed under Targeted News Analysis or TNA. The title for the first article is Contempt for Labor. The syllabus connection has been listed here for your benefit. The issue is related to the reviving economic activity that is supposed to take place after this COVID lockdown dissipates, and the dimension is related to the exemptions to welfare laws by states. So before we jump into the article, we need to have a brief background about what a Factories Act is. So we all know that companies work with the help of workers, and who is going to protect the rights of these workers. Otherwise, what happens is these companies might exploit them or extract as much work as possible from their workers without giving them adequate pay, without taking care of their safety or insurance or their health safety, and so on. In such a situation, it is important for us to basically pass a law which will regulate the working conditions of the people so that the interests of the workers are protected without compromising on the profits of the company. Okay, for this purpose we have come up with what is called as the Factories Act. And is this the first time that we have such an act? Not really. Even during our freedom struggle, we have had several Factories Act, especially during times of Lord Ripon and so on. Those were also basically measures which were intended to improve the working conditions of the people. Now coming back to the present Factories Act, we are currently discussing about the Factories Act of 1948. So the basic aim of this particular act is to protect the interests of the worker, protect their safety, welfare, and regulate their working conditions. This is the main objective of the Factories Act, and it has certain provisions under it which basically take care of this health, safety, and security of the workers. And is it applicable to only just few states in the country? No, it is applicable to each and every state in the country, including Jammu and Kashmir. So Factories Act is basically applicable throughout the country in all those firms which have more than 20 workers. So if there is a firm which has more than 20 workers, then it basically comes under the Factories Act. Now what are the steps that these factories have to adhere to? The first thing is that they have to ensure that the safety of their workers is paramount. In order to do so, if there are dangerous machinery, more protective equipment and health equipment is given for the workers so that they can go and work there in a safe environment. Next, each factory has to take care of certain measures in order to protect the interests and the health of the workers. Like for example, the cleanliness system of the factory has to be very nice. There has to be ventilation and temperature, dust and fume control, and there has to be steps to prevent any kind of overcrowding or artificial humidification or lightning. So all these are basically measures to prevent the workers from basically facing any kind of health problem. That is one aspect of Factories Act. Now the second aspect of Factories Act basically tries to prevent over exploitation of workers. It does so by basically regulating the amount of hours a person works per day. It says that you cannot work for more than 9 hours per day, and if you work for more than 9 hours per day, you are supposed to be paid some overtime money, which is a good amount of money which will incentivize you to work overtime. Otherwise, a factory cannot ask you to work overtime without giving you money. That is one point. And the second point is that you cannot work for more than so and so hours per week. Per week, you are restricted to work for only 48 to 50 hours. That is what this Factory Act says. And similarly, if you keep on looking at the different kinds of provisions of Factories Act, it is basically an overarching act which has several provisions which are related to different aspects of the working environment. It is related to the health of the worker in the environment. It is related to the safety and security of the worker in his environment, his insurance and the protection of women, and basically the facilities that are being given to women who recently have given childbirth. Factories can also have those kinds of workers, right? And all these measures are basically intended to provide some kind of support and regulate the working conditions in the factories. So this is the background of Factories Act. Now let's move on to understand what this article is trying to tell us. So because of COVID pandemic, the economy is not doing well, and we have been talking about this for quite some time. The economic activity has come to a standstill, and after this lockdown dissipates, we are basically trying to revive the economic activity. And the best way to revive the economic activity is to start the factories. And in order to boost the factory activity and the industrial activity, what different states are doing are basically they are basically diluting the Factories Act provisions for a brief period of time in order to make sure that they can extract as much work as possible from the workers in order to immediately put the factories on the profit path. Are the states allowed to do it? Yes. There are provisions under Factory Act which basically allow the state to ask for more work from workers in certain conditions. Like for example, you have Section 5 of the Factories Act. This permits certain exemption for its in relation to its provision for a period of 3 months when there is a public emergency. So if there is a public emergency, states can basically dilute the norms of the Factories Act and ask for more work from workers for the same amount of pay. This is what different states are trying to invoke at this point of time, and this is not good is what this article tries to say, because the public emergency which the Factories Act talks about is in relation to the national emergency. If there is a very big war-like situation and then you have to set up a national emergency, in such a condition, in the interest of national security, you can dilute the norms of the Factories Act to ask the workers to work more. But this is not such a situation. This is basically a health emergency, right? In such a health emergency kind of situation, it is not wise to allow the states to exploit the workers. So this article basically says that the dilution of the norms of the Factories Act by different states in order to put the factories on a growth path has to be balanced with the interest of the workers. So this article goes forward and says that the center should come forward. The center should come forward and basically prevent the states from basically diluting the norms of the Factories Act. Look, economic revival is important. Economic activity and the generation of wealth is important, but it should not come at the cost of the welfare of the workers. That is what this article says. So basically the center should make sure that states are able to balance the generation of wealth by factories on one side and protect the interests of the workers on the second side. So these two basically have to be balanced is what this article is trying to tell. Now let's move forward to our next article. So the title for our present article is Eradicate It. This is related to female genital mutilation. The syllabus connection has been listed here for your benefit. The issue, of course, is related to female genital mutilation, as I just pointed out. The dimension is related to the legal measures to address the problem of female genital mutilation. Now let's move on to the article. So this particular article is related to this awful practice of female genital mutilation. This is mostly practiced in African countries. And is it the case that it is only practiced in Africa? No, there are different countries in the world which basically practice this female genital mutilation, or FGM. Do we have it in India? Yes, some parts of India practice this FGM. In fact, there is a community called the Dawoodi Bohra community, which basically practices this female genital mutilation on their girl children, and in this matter has even gone to the Supreme Court or the judiciary. We'll talk about it later. We'll start off with what this article is trying to tell us. This article starts out by saying the recent measure that has been taken by the Sudanese government. The Sudanese government has decided to outlaw or totally ban this awful practice of female genital mutilation. So it has decided to ban this, and this is a landmark victory for women as such in that particular country. Because if you look at the UN estimates related to Sudan, nearly 87 to 90% of the women in Sudan have gone through this difficult procedure and painful procedure of female genital mutilation. And if you think about it, it not just affects the person physically, which it does anyway because the person's genitalia are being mutilated, it also scars them for life emotionally and mentally. We need to keep this in mind. But why do communities practice this kind of female genital mutilation? So there is some patriarchal norm, there are some religious reasons for it. The patriarchal norms basically try to curtail the female sexual drive, and they want to do it by mutilating the genitalia of women. That is one reason, and there are certain religious reasons behind it as well, which is why certain countries in Africa have been following this practice, and Sudan has recently outlawed it, and this is a product of the political transition that is taking place in that country. So what happened before was, before this period of time, for 30 years there was a dictatorship in Sudan. Okay, it was ruled by a dictator, and this dictator was basically a patriarch who was quite in support of this female genital mutilation. So this practice was quite rampant at that point of time, because it had the support of this dictator, it had the support of the religion, it had the support of certain social sects in that particular country. Now that this person is gone, this person is no more, there is a political transition in Sudan towards a more egalitarian government compared to the previous government, and this political transition has led to this very wonderful and egalitarian step of outlawing or totally banning this practice of female genital mutilation. So why are we taking just the example of Sudan? Are there any other countries in Africa which basically practice this FGM? Yes, there are multiple countries which do it in Africa, and the sad part is there is no legal ban as such in most countries in Africa against this procedure of female genital mutilation. Like for example, take the example of Somalia. Somalia does not even have a legal ban against this practice. And in fact, there is a young girl child who has died in 2018, which led to a huge uproar in the country. Even then, there was no ban as such. There was no legislation that has been passed in order to control this female genital mutilation. And the second thing is, even if there is a ban, even if there is a legislation which tries to ban this awful procedure of female genital mutilation, there is no proper implementation of this particular law. Let's take the example of Egypt. What happened in Egypt was, there was a procedure of female genital mutilation performed by a doctor with the support of the parent, with the support of the child's father, and this person has performed the operation on the girl child, and this has led to a problem, this has led to a huge uproar, so because of which it went to the court. But the court has let this person go free. Not only this, the court has also let the father of the child go free. So look at the deep rooted patriarchal and narrow tendencies that are prevalent in the societies in certain countries. Okay, so there should be a situation in which the laws become more egalitarian and they are supposed to be implemented perfectly. Like this, if we take the examples of Uganda, Kenya and so on, there are several cases of female genital mutilation. Until and unless there is an uproar in the community, in the country as such, in retaliation to this particular practice, there are no laws which are implemented to ban this practice. And even if the laws are usually implemented, they are usually implemented with no teeth, which is to say that they are implemented with no powers as such. So this situation has to change, is what this article tries to tell us by giving us examples of different countries of Africa. We have seen the example of Egypt, we have seen the example of Somalia, we have seen the example of Sudan, and then we talked about in passing reference about Uganda and Kenya, and there are so many other countries which basically perform this female genital mutilation. They are supposed to get rid of this practice. This gruesome practice has to be removed from the face of this African countries. Now we'll talk about female genital mutilation and some legality that is related to in India. In India, there are certain communities which basically perform this act of female genital mutilation because it is in relation to certain religious codes of particular religion. So this basically went to the judiciary, and in 2018 a bench of Mr. Justice Deepak Mishra has basically said that this has to be banned. But on the other side, the community is basically claiming that this is their right as provided by Article 25. So there is a deadlock between the judiciary and the community. The community is basically claiming its fundamental right of religion. The judiciary is saying that this is against the rights of women and the dignity of women as such. So it is an evolving topic, but the outcome which we are supposed to take from this particular topic in relation to India is that legislations are not sufficient. Even if you have a legislation, the implementation of the legislation is important. What is important is to improve the awareness of the people, to sensitize the men as such, to sensitize the communities as such to the needs and the sensitivities of the women. And when we do it, people will be more forthcoming to get rid of certain such awful procedures, is what this article is trying to tell us. Now let's move on to the next article. So the title for the next article is Shaping India's Response in a Global Hinge Movement. The syllabus connection has been listed here for your benefit. The issue is related to the changing geopolitical situation. What is this changing geopolitical situation? We'll look into it. The dimension is related to India's new role in such a changing geopolitical situation. So this article basically talks about the prevalence of a hinge movement in history in the world arena. So what does it mean? It basically means that there is an upheaval in the world order. Previously, for a long time, as we all know, that USA is basically the basic world hegemon. It used to be the strongest power in the world, be it in terms of its defense might, be it in terms of its economic might, be it in terms of its developmental parameters and so on. So it used to be the world power. Now this situation is changing. The center of gravity of power, which used to be close to USA or in the Atlantic Ocean, is now shifting to the Asia Pacific region. So the Asia Pacific region is basically emerging as the new center of power, with India and China as its basic bastions, as its basic pillars. That is what this article starts out by saying. So there is a shift in the center of gravity of power from the United States to the Asia Pacific region, which consists of India and China. And between India and China, we of course know that China is the bigger power here, be it in terms of its economic might, be it in terms of its forex reserves, be it in terms of its GDP value, and so on. So China is basically dominating the area in the Asia Pacific region. So this is a situation of a hinge movement. This is a kind of transition which has not been seen in the world for quite some time. This is the first point this article is trying to point out. The second point this article tries to point out is the contention that is developing between China and United States of America. If you look at the relationship between United States of America and China, they are not really happy with each other. They are not really in bed with each other. For example, they have a huge trade deficit. That is first point. And secondly, USA is skeptical of Chinese maneuvers in the region. China is basically trying to rise as a world power, and this is not being liked by USA, and which is why USA is trying to come up with several steps in order to curtail the powers of China, but this is not happening. So whatever be the case, these two countries are basically in loggerheads with each other. They have locked horns, and this situation is basically another kind of hinge movement. Next, this article tries to point out the role of India in such a situation. So look, the world is going through certain transition, and in such a transition there are two big countries, USA and China, which are basically not happy with each other. In such a situation, what is the opportunity that India can have? What kind of opportunities does India have? What kind of opportunities can India make in such a situation to emerge itself as a global power and to develop its national power, is what this article is trying to tell us. So the first thing we have to keep in mind is that China is the dominant power in the Asia Pacific region, and in such a situation, because China and USA are not happy with each other, we basically are supposed to engage with USA in order to make sure that the security of India in the Indian Ocean region is protected. China is basically trying to do what it is trying to basically dominate the Indian Ocean region. It has come up with a string of pearls strategy. It also has the OBOR, or the One Belt One Road initiative. It has these provisions in order to dominate the region as such. In order to put a counterweight to this particular kind of dominance, India must engage with the United States of America to make sure that its Indian Ocean is protected, to make sure that its national interests are protected. That is one opportunity that India is supposed to make. And on the second hand, if we lean too much towards USA, then our relationship with China will not go well. This is not good for India either, because the trade deficit between India and China is too much to bear for India. It is to the tune of $60 to $65 billion, right? In such a situation, we are supposed to engage with China also bilaterally in a good way. We have to get rid of our thorns, like the border issues and the other kind of security issues that we have. So we have to basically remove these issues between India and China and make sure that they come up with rules which mutually benefit each other. And if that is not possible, we are also simultaneously supposed to engage with all the other powers in the vicinity and above, and beyond in order to make sure that China behaves responsibly in the Asia Pacific region. We are supposed to build alliances in the region to make sure that China does not become the new hegemon, China does not become the new dominating person in this particular arena of Asia Pacific region. Now, this article moves forward and tells that India should basically take up this new role of protecting the global commons. So the whole world is basically going through a problem of COVID-19 as such. Even otherwise, the countries are basically having a huge trust deficit between each other, especially between USA and China, between USA and Russia, between USA and Iran, and so on. So there are several cases of trust deficit between the countries of the world. In such a situation, India should basically push forward the agenda of security of certain resources. So there is outer space, there is also the problem of internal security of different countries in relation, and also there is this problem of cyber security. In relation to these three problems, India should basically come forward with a strategy, with a measure to handle these three problems, and this strategy has to be pushed forward in the global platform so that people will be able to come and join this particular platform. That is what this article says. So India should basically make use of this hinge movement to develop nationally and also internationally, and at the same time make sure that it talks to other countries to basically push the agenda of cyber security, outer space security, and the internal security of different countries. So this is what this article says. Now let's move forward to the next article. So the title for the present article is NGT Cites Archaic Law in Gas Leak Case of Visakhapatnam. The issue is related to the gas leak case of Visakhapatnam. The dimension is related to NGT orders for the compensation in this particular disaster. So this article basically starts out by talking about the way in which the National Green Tribunal is handling the case of Visakhapatnam gas leak case. Before we do that, I hope all the people who are in Visakhapatnam at this point of time are safe and sound. Please make sure that you are in a safe distance from the LG Polymers industry and take care of your health. So before we move into what this NGT is trying to do, we have to understand two concepts. The first concept is the concept of strict liability, and the second is basically the concept of absolute liability. Now this may not be strictly important for the exam, but this is just for our knowledge. So these are basically legal terms. So when we talk about strict liability, when we say that a company is basically coming under strict liability, what we mean is it is not liable to any compensation if the disaster is caused by an act of God or by an accident. So if there is a company related to the hazardous industry and there is some industrial accident in that particular company, but the company is not really responsible for that particular disaster. It was done probably by an earthquake or maybe because of a flood, because of which the disaster has happened. There was gas leak, and this gas leak was probably because of earthquake, and which is an act of God. In such a situation where the company is not directly responsible for the disaster to happen, the company need not pay compensation. This is the concept of strict liability principle. Next comes the concept of absolute liability principle. The absolute liability principle does not take into account what the reasons are for the cause of that particular disaster. Whatever be the cause of the disaster, you have to pay the compensation. I do not mind whether it is done by an act of God like an earthquake. I do not want to know if it was because you were negligent in relation to your equipment. Whatever be the case, you are supposed to pay the compensation because you have set up a hazardous industry. So this is the basic concept of the difference between strict liability and absolute liability principle. So the National Green Tribunal has basically charged the LG Polymers with the concept of strict liability. Now this is not good, is what this article is trying to claim. This article basically says if you basically put up strict liability for LG Polymers will show that this is just a case of accident. Because of COVID lockdown, we basically could not take care or keep in condition our equipment, because of which it led to the gas leak. And when they do that, they are basically not going to give any kind of compensation to the victims, and the number of victims are very high. In such a situation, you are supposed to use the concept of absolute liability, is what this article is trying to tell us. Next, this article tries to give us certain facts. So there was this oleum gas leak case in Delhi. In that particular case itself, the Supreme Court or the judiciary has said that the concept of strict liability is totally inadequate to protect the victims of that particular disaster. So because in strict liability, the company may or may not pay the compensation, it is not really possible to provide any kind of rehabilitation to the victims in such a case. So the Supreme Court in Oleum gas leak case, the judiciary in Oleum gas leak case has said that we have to adhere to the concept of absolute liability. But after it has said that, if NGT is coming back and is saying that LG Polymers is coming under the concept of strict liability and not under absolute liability, it is a basic problem that we have, and we are not supposed to have this kind of situation. NGT is supposed to hold LG Polymers under absolute liability, so adequate compensation is paid to all the victims of that particular disaster, is what this article is trying to tell us. Now let's move on to the next article. So the title for the present article is Phase 2 Trial with 3 Drugs Offers Hope. The syllabus connection has been listed here. Please have a look. The issue is related to COVID-19 and the dimension is related to the vaccine trials. So this article basically talks about the mild success that has been reached in the medical trials related to the COVID-19. So as we all know, different countries are trying to come up with vaccines and medication in order to protect people from COVID-19 pandemic. So the set of Hong Kong researchers have come up with a 3-drug regimen. They have come up with a combination of 3 drugs in order to handle the situation of COVID disease. I'll just list down the names of the drugs. They are not so important, but let's have a look. So the first drug goes by the name lopinavir ritonavir. So this is used for the treatment of HIV in general. And the second drug is basically ribavirin for the treatment of chronic hepatitis C virus. This drug is basically used. And the third drug is basically injectable interferon beta 1b. And where do we use this particular drug? We basically use it in the treatment of patients with multiple sclerosis. So basically these 3 drugs have been combined, and this 3-drug regimen is administered to a control group of patients, which we call as the clinical trials. And in these clinical trials, people who have been given this 3-drug regimen, they have showed very positive results, is what this article is trying to tell us. Now once we get this kind of good result after phase 2 of trial, can we basically launch that product in the market? No. We have to basically go forward and test the drug on a lot of people, on a good number of people, to make sure that there are no long-term side effects of this particular drugs, right? So these chemical allopathic drugs usually have some kind of side effects. Before we assess the side effects of these drugs, we cannot administer these drugs to the general normal populace. So after this phase 2, these Hong Kong researchers want to go to the step of phase 3, and in phase 3 a more number of patients with the symptoms of COVID-19 will be tested, and their response to this particular 3-drug regimen will be assessed. And if that basically succeeds, then there is a chance that this drug comes into the market and make sure it can eliminate the COVID-19 pandemic. So this is what this article says. The 3-drug regimen is basically given by Hong Kong researchers. That is one point. And the second point is just the names of the drugs. You might want to list them probably in your mains answer, but otherwise they are not so important because they are too technical. But clinical trials and the concept of clinical trials are important. Now let's move forward to the next article. So the title for the present article is Ration Card Portability Usage is Low, says Paswan. The syllabus connection has been listed here for your benefit. The issue is related to ration card portability, and the dimension is one nation, one ration card. So this article basically is related to the concept of one nation, one ration card. We need to have a brief background about what this particular scheme is. This scheme basically makes sure that the migrant population can have access to the PDS benefits in whichever state they are. So we all know that the public distribution system tries to provide subsidized food grains to the poor people. Now if the poor person is a migrant worker, when he moves from one state to another state, what opportunity does he have? Should he basically let go of his benefits of PDS? No, right? So the state, as in the government, should basically make sure that this person, wherever he is, because he is poor, he should be able to access this PDS benefits. And in order to give effect to that particular thought, we have come up with one nation, one ration card. Once you have this kind of card, in whichever state you are, you basically can go to the ration mandi and get your subsidized food grains by giving your biometric print. right? So that is what this one nation one ration card says. But sadly, this article tells us that the usage of this one nation one ration card is very less. So around 60 crore people are basically covered under this particular scheme, this particular ration card portability scheme, but the interstate usage has been very low in relation to this scheme. That is a sad thing. And the second point is, the reason why this usage is low is because a lot of people, a lot of these migrant workers are not aware that there is this portability of PDS. They think that if they have a ration card in a particular state, they can avail PDS benefits only in that particular state, right? They do not have the awareness that they can go to any state they want and show the ration card and get the PDS benefits in terms of the food grains they purchase, and this kind of awareness is low. That is first point. And secondly, most states have basically suspended the biometric authentication. If the biometric authentication is suspended, when the person goes there, how is his poverty authenticated, how is his ration card authenticated? When that does not happen, it will be really difficult for the state to assess whether he is a beneficiary or not. It will be really difficult to give the PDS benefits as such. So that is another reason why this one nation one ration card has failed during the times of COVID-19. But this article is quite hopeful about the fact that if we are basically able to revive this one nation one ration card, the migrant workers will basically decrease their troubles. The main problem of migrant workers at this point of time is because they are stranded. They do not have any livelihood opportunities. Their income sources have all dried up, right? This is creating a lot of trouble for them. They are not able to access food grains as such because they do not have money to purchase the same. But their PDS cards are belonging to different state, and they don't know that they can access food grains in the very state they are staying using the original PDS cards. So basically, we are supposed to create awareness across the nation among all the migrant workers that they can avail the PDS benefits wherever they are by showing their ration card, and the states on their part have to make sure that they can revive the biometric authentication using the principles of social distancing, and this will be able to solve the problem of migrant worker food hunger to a certain extent, is what this article is trying to tell us. So the title of the last article is Mass Hatching of Olive Ridley Turtles Begins at Odisha's Rushikulya Rookery. The syllabus connection has been listed here. The issue is related to olive ridley turtles and the dimension is related to mass hatching. What is mass hatching of olive ridley turtles is called, by the way? It is called as Arivada. Olive ridley turtles is a very important topic in relation to the prelims examination. We need to know each and every fact that is related to olive ridley turtles. But the usual questions which come up in relation to any mammal or organism or any animal as such is whether its status is vulnerable or extinct or endangered or critically endangered and so on. Its IUCN status, of course. So if we look at the IUCN status of olive ridley turtles, it is vulnerable. You have to keep this in mind. And secondly, these turtles basically try to nest in masses. So they come in groups and hatch their eggs. And this process of mass nesting is called as the process of Arivada. Is olive ridley turtle the only turtle which exhibits this phenomenon of mass nesting? Certainly no. There is one other turtle which exhibits the same phenomena, that is called as the Kemp's ridley turtle. So both Kemp's ridley turtle and the olive ridley turtle exhibit this process of mass nesting called as the Arivada. They basically hatch their eggs, and these eggs come out of the sand and they go to the ocean directly and they start swimming. This is the process of Arivada and the incubation process of an olive ridley turtle. So where do we find this olive ridley turtle in general? It is endemic to certain areas like the Pacific coasts of Mexico, the Central America, and in India. And in India, where do we find this particular olive ridley turtle? We find it in the coast of Odisha near the Gahirmata beach. The mouth of a river, the Rushikulya river, is basically the place where these olive ridley turtles come every year. So these are certain facts which are related to olive ridley turtles. The government of Odisha is basically trying to come up with several steps in order to make sure that they have a safe environment in which they can hatch their eggs. The government basically prevents any kind of shipping or fishing during the time in which this hatching happens. That was one step that was taken. And the second step that was taken was to prevent any kind of lights in that area, because if there are lights in that area, if there are any street lights in that area, the small hatchling hatchlings which come out of the sand, instead of going into the sea, they start going towards the lights, and we don't want that. So the lights are basically switched off during the nesting time, so these hatchlings can go directly into the sea and start their long journey. This is what this article's backgrounder is. Now what this article is trying to tell us is that Olive Ridley turtles have started their hatching in the Rushikulya rookery. Thousands of hatchlings have come out of their nests because their incubation is over, the gestation is over, they are out, and they are basically trying to crawl towards the sea to start their long journey to probably to the Pacific and so on. Now, on an average, how many turtles hatch from each nest? About 80 to 100 turtles hatch from each nest is what this article says. And this particular year, we have as many hatchlings of about 3,23,063. These many turtles have hatched in near the Rushikulya rookery is what this article is trying to tell us. This is just a set of facts that this article is trying to give us, but mostly the facts related to Olive Ridley turtle, whether it is vulnerable or endangered, etc., is important. Its endemic areas is important. The process of Aribade is important for a prelims examination. Now let's look at certain prelims questions. So let's look at the first question. The first question is the following. Consider the following statements about the female genital mutilation, which was recently banned in Sudan, right? There was a political transition in Sudan from the dictatorship to the present government, and this present government is more egalitarian, so it has banned or outlawed the practice of female genital mutilation. So the first option is FGM involves removal of partial or total removal of external female genitalia. This is right so far. And then it says it is mainly to save the young girls from adolescent infections. Definitely not. This does no benefit to the women as such. It does only harm both mental and physical. Next option is FGM, though present to some extent in African countries, is highly prevalent in Central American and South American countries. No, it is mostly prevalent in African countries. So second option is also wrong. And the third option is the idea behind FGM is accepted internationally, but the crude nature of the procedure used to carry out FGM is not. No, the idea of FGM is not accepted internationally. It is basically an awful procedure which violates the bodily integrity of women as such, which is why it is detested by all people, people all over the world, except certain communities which are in support of FGM. So all the three options are wrong. So the answer is D. But before we move forward to the next question, I'll tell you a trick. The first option is what? The first option basically says that it is related to saving young girls from adolescent infections, right? And I know that this option is wrong. Immediately when I know that this option is wrong, I can eliminate option A, B and C. So even without reading these two options, I got my answer. Sometimes this kind of trick becomes really handy in your prelims examination because you cannot really decide between these two options. What happens is you have to go through the process of elimination to come towards your answer. Otherwise, it will be really difficult to first look into all the three options and see what is right and what is not right. So you have to be smart in your elimination. Now comes the next question. Which among the following are the major provisions contained in the Factories Act? Okay. The major drawback of this act is that there is no cap mentioned on the number of working hours, mainly to boost the industrial productivity of India in 1948. No, there is definitely a cap. You can have a cap of 48 hours per week and 9 hours per day. This is definitely there. So the first option is wrong. So I know that option A and C and D is wrong. So my answer is B. But anyway, let's read out second and third options. The act provides for underground manholes to escape in case of any accident. Yes, this is one of the provisions that is there in the act. The act is applicable only to those very large factories which significantly contribute to the national economy. This is not right. All those factories which have 20 or more workers are basically liable to be coming under this particular act. So this completes the discussion for the day. Thank you for your participation. We'll meet again.